Welcome all. Uh, Today's topic of discussion is Right to Information Act. Subject is Pharmaceutical Jurisprudence, code BP 505T. So, Right to Information Act is also known as, short form is RTI. So, you can see here the Right of Information Act 2005, okay, and number 22 under the section of 2005, 15 June 2005 it has been, this act was implemented. This is an act to provide for setting out the practical regime of right information. The word is right information for citizens to secure access to the information under the control of public authorities. Means the secure access to any information, okay, under the control of the public authorities in order to promote transparency and accountability in the working of every public authority. The constitution of Central Information Commission CIC and State Information Commission, that is SIC, and for matters connected therewith or incidental thereto. Okay. So, this is the provision given by this is an act which is given by the government, which is basically to provide right information to the citizens, okay, right information to the citizens, so that they should access any kind of information if they want under the control of public authorities, and the purpose is to promote transparency and accountability. Okay. So, promote whatever the work they are doing, there should be transparency in this, and accountability is also should be there. So, this is the purpose of Right to Information Act. So, Right to Information is an act of Parliament of India, okay, which sets out the rules and procedures regarding citizens' rights to information. So, what is this is the right of information है, ये Parliament of India की तरफ से set किया गया हुआ है, and it has framed the rules regarding citizens right to information. Former it was said as Freedom to Information Act. In 2002, Freedom to Information Act has been replaced by RTI. Okay. Under the provisions of RTI Act, any citizens of India may request information. So, any citizen of India may request information from the public authority or from the government side, a body of government or instrumental of state. So, public authority means government and institution of the state, means central government as well as state government, which is required to reply expedientially or within 30 days. So, this act is whatever the अगर किसी ने भी वो दिया हुआ तो within 30 days they are supposed to give the answer. In case of matter involving a petitioner's life and liberty, the information has to be provided within 48 hours. So, though the condition apply is they are supposed to give within 30 days, but if there is a petition, if there is the involvement of petitioner's life and its liberty, then the answer should be provided within 48 hours. The act also requires every public authority to computerize their records for wide dissemination and proactively publish certain categories of information, so that the citizens need minimum resources to request for the information formally. Okay. So, this act also provides a provision that all the information should be proactively uploaded on the computer site or the website, so that whatever information can be accessed, it can be accessed by the citizens at any time. This law was passed by Parliament of India on 15 June 2005 and came in full existence into on 12th October 2005. Every day on an average over 4,800 RTI applications are filed. So, in first 10 years of commencement of the act, over 1 crore 75 lakhs applications had filed, means the information that is the rate of soon after the implementation of this law, many people indulged into getting the information from government side, from the government. Okay, continuing the same, although the right to information is not included as fundamental right, okay, though this is not a fundamental right in the Constitution of India, but it protects the fundamental rights of freedom of expression and speech. Okay. So, fundamental rights may directly it is not involved, but indirectly it is there. Fundamental rights to freedom and expression of speech को और strengthen करने के लिए this right to information act has been added under the article 119(1)(a) and right to life and personal liberty under article 21 guaranteed by the constitution. Okay. The authorities under RTI Act 2005 are called public authorities. So, the authorities which are under RTI Act means those who are supposed to give the information to the public domain, they are known as public authorities. Okay. The public information officer or the first appellate authority, okay, means the public information officer or the first appellate means दो सबसे पहले अपील करने वाली authority in the public authorities perform quasi judicial function of deciding the application and appeal respectively. So, the basic the first, if the applicant has applied for RTI, this is supposed to go to public information officer or the first appellate authority, and after seeing into the condition whether the information is suitable, and then a decision is taken to provide the information to the applicant. This act was enacted in order to consolidate the fundamental rights in the Indian Constitution's freedom of speech. Since RTI is implicit in the right to freedom of speech and expressions under article 19 of the Indian Constitution, it is implied fundamental rights. So, though directly it is not there in the fundamental rights, but indirectly it is और मजबूत बनाता है हमारे freedom to speech जो rights है उसको और strong बनाने के लिए इसको use किया जाता है. Now, next is RTI and need for it. Why RTI is required and what is its need? Right to information basically means the citizens' right to get information from government, and its various instruments. Various instruments means government की जो system concern जो associated होते हैं at all levels which are substantially financed directly or indirectly by the government, known as public authority. Okay. As a matter of right within a stipulated time frame bearing exceptions. Okay. So, they are supposed to give the information the government or the various instruments at all level. Okay. So, they are supposed to give all the information to citizens of India within a stipulated time, and also they will look for the some exceptions where the information has to give or not. Okay. In India, the need of right to information has been felt by the people since independence because the existence of Official Secrets Act 1923, which was enacted by British during the colonial era. So, during their era, British government, they have put a law known as Official Secrets Act. According to that act, they are not supposed to open or share their information in the public domain. So, since that law was coming from past, so all the information were kept held with the government itself. So, there was a need to overcome this law, that is the Official Secret Act. There was a law which should overcome this, and that is why a Right to Information Act was introduced. Now, the governance and the process. The right to information in India is governed by two major bodies. First one is the central body, that is known as CIC, that is Central Information Commission, and the State Information Commission, that is SIC. The Chief Information Commissioner, who heads all the central department and ministries with their own public information officers, PIOs, and CICs are directly under the President of India. Okay. So, central information, some informations are there in the central government level and some informations are there at the state government level. Okay. So, the central CIC is under President of India, under the headship of President of India, and State Pharmacy Commission is under the headship of state government. Okay. So, state information, we can see the State Information Commission, the State Public Information Officers or SPIOs head over all the state departments and ministries. The SPIO's office is directly under the corresponding state governor, not government, governor. Okay. So, central ke liye President of India and state ke liye governor of that particular state. Now, what are the salient features of RTI Act 2005? The Act gives every citizen to seek information from any public authority, whether owned, controlled or substantially financed by government. So, any information by the authority, public authority, or whether it is owned by anyone or controlled or substantially financed by government. Information means any material in any form, including records. So, what are the informations they can the public can get? Records, any documents, memos, emails, opinions, advices, press release, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material in any kind in electronic form. See, all the information related pertaining to whatever has been furnished here, all the information related to this can be obtained through RTI. A citizen who wants the information just needs to make a request. So, what is the procedure? Just needs to make a request in the writing in a plain paper में भी लिख सकते हैं, or through electronic means, okay, in English or Hindi, also in official language of that particular area which the application is being made. Okay. The citizen can get assistance from the central or the state public information officers in writing down the applications for request and filing the application. So, simply by writing or by the electronic means, anyone can, in any language it can be done. The public authority needs to provide the information as asked by the citizen within 30 days. This is the time framework of the receipt of the request, and if the information concerns to the life and liberty of any person, then information should be given within 48 hours. Okay. Within 48 hours this information has to be provided. The Act also provides for exemption from certain types of information from disclosures, especially related to security and integrity of the country, but all the information related to national security and integrity of the country, those information cannot be shared with the in public domain. This is also protected by the RTI Act. The citizen enjoys the redressal mechanism in the form of appeal and complaints if he does not receive any information within the stipulated time period or is aggrieved by the decision of the central or the state information officer. Okay. So, if he feels कि वो information उसको नहीं मिला हुआ है, aggrieved मतलब पीड़ित है और stipulated time में उसको information नहीं मिला हुआ, in that case penalty of ₹250 per day will be imposed, okay, upon the officers who fail to comply with this act. Okay. But however, the total amount of penalty will be subject to maximum 25,000, and this penalty will go up to 25,000 if information is not provided by the government servant. RTI and obligations of public authority. Every public authority shall maintain all its records duly catalogued and indexed in a manner and the form which facilitates right to information under this act. Okay. So, all the information should be well catalogued, matlab well organized and well indexed, and they should also ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources, computerized and connected through a network all over the country on different systems, so as to access such records is facilitated. If the information is very large and it cannot be provided by say hard copy, so all the information should be uploaded in by the electronic way, and it should be published on the particular website, and from there the applicant can draw the information. Next, a person who desires to obtain any information under this act shall make a request in writing or through electronic means in English or Hindi or any official language of this area. Application is being made accompanying such fees as may be presented. A central public information officer or a state public information as the case may be of the concerned public authority. Second, the central assistant public information officer or state assistant public officer information officer as the case may be, specifying the particulars of information sought by him. So, any information the applicant, if he knows कि central government से information निकालना है, then he will write to central public officer. if अगर state में डालना है तो state information officer को डालेंगे. Okay, what are the penalties? Penalties imposable by information of commission on PIOs or officers asked to assist PIO for unreasonable delay. This is what we have discussed, 250 rupees, and maximum it will go to 2000 25,000 rupees. Okay. And 25,000 rupees. Opportunity of hearing should be given. Okay. Commission can grant compensation for loss of suffered by the applicant due to non provision of information. In case अगर information नहीं provide किया गया 250 rupees per day, maximum 2000 25,000, और उसके बाद फिर opportunity of hearing will be given, okay, to the applicant, and commission can grant compensation, और उस टाइम पे कंपनसेशन भी अप्लीकेंट को दिया जाएगा अगर उसके इंफॉर्मेशन टाइम पे नहीं मिला और उसके वजह से उसकी कोई लॉस हुआ है तो. सो फीस, व्हाट इज द फीस? A citizen who desires to seek some information from a public authority is required to send along with the application a postal order or a DD or a banker's check payable to the account officers of the public authority as fees prescribed for seeking information. If a person is from a disadvantaged community, there is no need to pay any fees. The applicant may also be required to pay further fees towards the cost of the providing the information, details of which shall be intimated to the applicant by PIO, okay, as prescribed by the RTI Act. So, different states has different facilities. Okay, some states has charges only rupees 10, some state charges rupees 50 for applying RTI. Okay. And further information, if we want deeper information, further extra fees is also required to pay by the applicant, which is intimated to the applicant by PIOs to time. Digital right to information system, a digital portal has been set up, RTI portal, a gateway to the citizens for quick search of information on the details of the first appellate authorities. Appellate means the appeal, the first appeal authorities, PIOs, etc. amongst others. Besides access to RTI related information disclosures published on the web by various public authorities under the Government of India as well as the state government. It is an initiative taken by the Department of Personnel and Training, Ministry of Personnel, Public Grievance and Pensions. Amendment. The Right to Information Act 2019 passed in July 2019 modified the terms and conditions of the service of CIC, Central Information Committee, and information commissioners at the center and in states. It had been criticized as watering down the independence of the information commissions. Also, there is a Supreme Court judgment also. Supreme Court of India on 13th November 2019 upheld the decision of Delhi High Court, bringing the office of Chief Justice of India under the purview of Right to Information Act. So, Chief Justice of India को भी include किया गया to provide the information to public domain, which was not there earlier. On 13th November 2019, this is the judgment given by the Supreme Court that the Chief Justice of the India is also purviewing the Right to Information Act. Okay, what is not to open? What is not open to disclose? So, there are many things which cannot be disclosed. PIOs may reject a request for information of any grounds mentioned in this clause within 30 days. Okay. Section 8(1) exemptions from the disclosure. So, what are the exemptions? Any issues related to national security, information disclosures of which would prejudicially affect the sovereignty and integrity of the India, the security, scientific or economic interest of the state, relation with foreign states, leads to instrument of the offences. So, any documents related to national security cannot be shared. Contempt of court, information which has been expressed forbidden to be published by any court of law or tribunal, or disclosure of which may constitute contempt of court. If the court has asked to keep the if the case is under trial and no information should be disclosed, and public cannot ask for what is happening inside the court until court orders it. Parliamentary privilege, information the disclosure of which would cause a breach in the privilege of parliament or the state legislations. So, parliamentary information cannot be disclosed. Trade secrets, information including commercial confidence, trade secrets or intellectual property, the disclosure of which would harm the competitive position of the third party, unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. So, any trade secrets means the business के बीच में जो भी secrets होते हैं किसी कंपनीज के बीच में आपस में, वो सीक्रेट्स को शेयर उसको RTI एक्ट ने प्रिवेंट किया हुआ है अनलेस एंड अनटिल सम कंडीशंस आर अप्लाइड. नाउ फिड्यूशियरी रिलेशनशिप, ओके, मीन्स फिड्यूशियरी का मतलब होता है trustworthy relationship, information available to a person in his fiduciary relationship unless the compensate authority is satisfied that the larger public interest warrants the disclosure of such information. अगर बहुत ही trustworthy information है एक दो persons के बीच में, you cannot ask for those information unless and until authority or the government is satisfied that the public interest is more than that of keeping the secret. In that case, that can be disclosed, otherwise it cannot be disclosed under RTI. Okay. Foreign government information, information received in confidence from the foreign government, these informations cannot be asked under RTI. Safety of informer in law enforcement, information the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance cannot be shared with public, given in confidence for law enforcement of security purpose. If anything is related to the disclosure or would endanger the life or physical safety of any person, such type of information can also not be shared. Investigation, information which would impede, which can slow down the process of investigation or apprehension, that cannot be also shared under RTI. Cabinet papers including records of deliberations of the council of ministers, secretaries and other officers, this can also not be shared in public domain. So, what are the amendment? The Lok Sabha had passed the Right to Information Amendment Bill 2019 on 22nd July. In this amendment, it is proposed that amend to Right to Information Act 2005 so as to provide that the term of office and the salaries, allowances and other terms and conditions of the service, Chief Information Commissioner and the Information Commissioners and the State Chief Information Commissioner and the State Information Commissioner shall be such as may be prescribed by the central government. This is the amendment they did. Okay. So, this is all about Right to Information Act. The information has been taken directly from some website of RTI government site also, and this is all about Right to Information Act.